Members, we have formed a quorum and it's also the appointed time. Please invite the administration to join us.
Listen. 咁就今日咧就除咗
For today's meeting, we have officials from the Health and Welfare Bureau who are familiar faces, and we are pleased that Mr. Gregory Leung, Chairman of the Council on Human Reproductive Technology, are also present. On the 9th and also the 29th of April, we put some questions to the administrations, and we have got response from the administration. Please refer to CB2 1309/1415-04 and also 1337/1415-02 and 1426/1415-01. Perhaps I give the floor to Mr. Davy Jong for an introduction to the paper. Last Friday, we issued a paper which is a little bit longer, hoping to respond to most of the comments raised at previous meetings. Because we didn't respond to some of the issues sufficiently, I would like to present the whole picture to members through these papers. On individual issues, members may have questions. I will just give a summary of my paper. In fact, it is about the drafting of the bill, because at previous meetings we understand that members support the policy intent behind the bill, and the major issues are with the drafting aspect. In fact, we have considered very carefully as to the scope of the bill at the drafting stage, where we narrow the scope to restrict the use of sex-selective, to restrict advertisements on sex selection services. And we believe our approach will not affect medical health care staff that have to do this for genuine need. And I think they will not be caught by the new offenses. Some individuals, organizations may use workshops and educational events for the purpose of promotion and publicity. We believe the way we draft the bill should be able to make a distinction between the two. Academics and doctors who are genuinely engaged in educational activities will not be caught. And the paper is rather detailed on things we've considered during the drafting stage and how we deal with the internet in enforcement. And we've also included some possible issues we may encounter during enforcement and our handling. The Assistant Legal Advisor has raised a lot of comments on hyperlinking, and at the back of the paper, we've tried to respond to these comments one by one. some members and organizations asked if we can add defense provisions for exemption purpose, for instance. In fact, the new offense would only apply to promotion of or advertisements on the use of HRT for sex selection. For the examples quoted by the legal advisor, they may not be entirely the same. So we have no intention to provide defenses in the bill because we may inadvertently create loopholes for people to abuse. So that's an overall response to comments made by members. And just a few more sentences. At the first meeting and also at the meeting of deputations, members raised questions about the Council on HRT. On the 27th of April, we submitted a paper to members, and there is a separate section on the Council. And in the latest paper, in the last few paragraphs, we responded to comments by the deputations specifically, and we have also got the chairman of the council with us. Perhaps I pause here first, Chairman. Yes, we note that at the last meeting, many deputations had queries about the work and procedures of the council on HRT or the CHRT. And we're happy that the chairman, Mr. Gregory Leung, is with us this morning. The CHRT can be found in para C or point C of the paper. We don't want to take up too much of Mr. Leung's time, and if we go through the paper according to the sequence there, we may have to keep Mr. Leung waiting. So perhaps we deal with this section on CHRT of the paper first. And then deputations had some comments on the procedures and work of the CHRT. So may I invite members to focus on the CHRT first. In fact, the response paper has got a lot of issues of concern to us. For instance, mens rea, the definition and scope of advertisement, and definition of sex selection service, hyperlinking, and overseas websites and servers, so on and so forth. I want to have sufficient time for each section. I would also like to give time for our legal advisor to respond to these different sections. So can we first focus on the CHRT first? Mr. Chen Chi-chun. Thank you, Chairman. I will first focus on CHRT. At the last meeting, some deputations gave us very specific examples. However, from what we have from the administration, the quickest, the fastest is 10 days. Some members, some deputations asked about this, and for complicated cases, there is no time frame specified here. And the issues raised by deputations were not answered, and now the administration referred them back to the provisions again. So can we have some more specific answers from the administration? And we said that there is no expert on HRT in the council. But then again, as I said, there is an obstetrician there, and some members asked well, even if you don't allow me to vote, you should allow me to join in the deliberations. And you say that there may be conflict of interest. This is unreasonable. And you said that where necessary, experts would be invited to incorporate their expertise. But how many times have you invited specialists on HRT to your meetings? Even joining in the discussion would lead to conflict of interest. And some deputations ask, what about neutral HRT specialists from overseas? Of course, somebody may say that, well, we have those specialists in Hong Kong. Why do we need them from overseas? Mr. Leung.
First of all, respond to your question. Of course, the Secretariat would receive many inquiries, some from the general public and some from treatment centers. The Secretariat would usually, after reading the inquiry, as Mr. Chen said just now, would reply in a written form and to list out the regulations clearly, and in order for the inquirer to read it, would list out also which article, which ordinance it belongs to, so that you wouldn't need to refer back to other legal versions. So, of course, we would look at the legal perspective and also to consider the individual case before coming up with a conclusion or decision on whether it is possible or not. If you need to put in a written inquiry, usually it's quite complicated and not a simple case. So you would have to look at all the details before coming to a decision. The council or the Secretariat cannot just make a decision based on a written inquiry, because that would be very irresponsible behavior. And it's also unfair because the legal liability would basically be on the shoulders of the service provider. The ordinance is not set by the council. The council cannot interpret the law. Thank you. Chairman, sorry, Mr. Chen, how about you wait for another round, because you've already made 5 questions in 5 areas. You want to see why there is no expert on human reproductive technology on the council. And according to the paper, you said that there is a conflict of interest in recruiting such experts. So have you ever recruited the service of such experts on the council? If yes, have you ever sought advice of overseas experts, and how much public funding are we talking about it? How about we let him address all these questions before you make any follow-up questions? How about I invite someone else to address this question, because the council is appointed. Well, so if you believe that if you appoint a HRT expert there would be conflict, could you explain what you mean by that? Well, what I mean is that, well, talking about licensees or responsible people in the sentence, we cannot just appoint them. Let me give you an example. It's written under the law. If that person is a member right now, but he became the license holder, he would have to give up his seat on the council. But not all HIT experts in Hong Kong are license holders, right? Well, I'm not trying to ask you this question right now. Well, Mr. Leung, you want to hand over the question to Mr. Chung? Yes. The Constitution is written. Yes, we can see that. Well, number 1, here it said that it already include experts in obstetrics, so or in gynecology. Well, of course, these people would have knowledge in these areas. Well, let me take a look at this from another view. We look at the overall responsibility of the CHRT. It's mainly responsible for issuing licenses on inspection or to deal with complaints and to investigate complaints and to look at related penalties. So when we are talking about licensing, if a person who holds a license participates in the council, then we believe that there is a conflict of interest. Well, Chairman, he said that if a license holder joins the council, then there's a conflict of interest. We don't want to see license holder. We're talking about HRT experts joining the council. Mr. Chung, all those who have engaged in reproductive medicine are not licensees, and they do not have any conflict of interest. If you put it that way, there are lots of stakeholders in the buildings department, and Mr. Mock is seated here as well. All those who are knowledgeable in that area of expertise. Then that means that if you use your explanation, there would be conflict of interest for all our members in sitting on certain boards. So do I understand from you that, that stakeholders are not supposed to sit on the council, or is it only limited to the council on HRT? This is a very major issue. Well, we understand that, that there might be conflict of interest. You could see that, for some cases, the ICAC would even investigate matters. But we're talking about quite a specialty here. Is this a policy of the government, or is this only a special case for the Council on HRT? I think we are talking about licensees. Well, what if, they are not experts who are also licensees? Have you tried to appoint anyone who is knowledgeable in this area? Mr. Leung, yes. In the past, yes. Not in the council, but in working groups under the council. We've had experts in our working groups before. So that you mean to say that, yes, in the past you've appointed experts on working groups, but now we don't have any HRT expert in our working groups under the council. Am I right? I mean, this is a huge problem. That means that if everyone in the council is not working in this area, that's not good news. Well, we do have people knowledgeable in the area. Dr. So, Professor Tang worked in reproductive technology before he retired. He's still our council member. We have also invited reproductive medicine doctors to act as our council members, and they are not licensees. But when we request them, or when we request for a further reappointment, then they declined. So Dr. Tang has already retired. He is not working in reproductive medicine. No. Well, there are two Dr. Tangs. Which one are you talking about? Professor Lawrence Tang. Dr. Lawrence Tang. All right. Now, Mr. Chen asked two questions. One on whether any experts have been invited or overseas experts invited to sit on the council. Well, for overseas experts, in my few years on the council, I don't believe there are any overseas experts. But for local experts, as I've said earlier, we've had professors from local hospitals who have sat on our working groups and who have participated in our discussions. Mr. Chen, many deputations attended our last meeting and said they hope to see expert on the council. Well, you are worried about the licensee issue. If it's not because of the licensee issue, can you at least, appoint one or two experts? Of course, the law said that it doesn't necessarily have to be experts in reproductive medicine. It could just be persons who are in the practice of obstetrics and gynecology. But I think it's better if they are experts in reproductive medicine. Well, I think that when inquiries are made, they know which ordinance or which article they are referring to. Have you ever reflected to the government that there is some gray area in the ordinance, that there should be reviews made? When was the last review of the ordinance? We've already talked about this with the government, and we know that some sort of review needs to be done because there are some sort of gray areas, and we would attend to those areas. So which part, Dr. Leung, are you talking about? And for proposals for amendments, have you already submitted it to the government, or do you already have a timetable set out? Well, it's all very trivial. For example, explanations on how you interpret the law. A recent example that we've been looking at is the term parties to a marriage, because there is no clear interpretation in the law. So we need to look at the most appropriate definition for this term. And there are no precedents as reference. So we are still looking into the matter. How about a timetable? Have you already looked at the timeline? Well, we are still talking or discussing with the government. So it's now under progress. When would a review be conducted? Mr. Chong? We have representative on the council, and there's also representative from the Food and Health Bureau. I think that there one or two times we discussed it, and I think we would need to talk about specifics with the government before we could come up with a timeline. I want to point out that there are many considerations behind the ordinance. We not only talk about the medical procedure, we also need to discuss ethical issues. And so I think we would need to conduct a major public consultation, and it might be a consultation even bigger than the one we just held. Because this is quite a sensitive issue, we want to deal with it in a prudent way. We know that the industry needs time to adjust. We are also ready to look into it and to start work to try to review the ordinance.
Now they have finally brought out the issue, the whole HR2 ordinance should be reviewed. Perhaps some of the provisions enacted in the past are not clear enough, and this time provisions in the bill may also be not clear enough, and they use the provisions and ordinance to support this mode of enactment. So I urge the administration to conduct a full review of the HRT ordinance. It's pointless for us to keep arguing over the contents. Some deputations asked the following. They're not too sure about the replies from the council. The chairman said that they would not recommend in their reply whether the procedures should be done or not, and the proposal is where in doubt, do not do it at all. We understand that many patients who needed help in Hong Kong could not receive the service and went to the U.S. Instead, as we all know, the U.S. or Thailand do not have such stringent controls, and this has caused the subject himself to spend much more money, and this will also affect the development of HRT because the provisions are not clear, cannot be clarified. People would rather not do it, and technology in this regard cannot advance in Hong Kong. So, Mr. Leung, can you comment on such views? And secondly, people would really want the council to give them a clear direction as to whether the case can proceed. So, other than seeking help from the council, are there other avenues for people to consult so that they can decide whether the procedures can be done or not? Because HRT is not just a simple medical procedure. There are legal and moral and social issues to be considered. So, now, if in a particular case, the medical service provider, well, of course, the medical diagnosis can be done by the doctor. For the service recipient, the background and what's more, the circumstances under which the donor donates his sperms or gametes, well, these details are critical to whether the procedure can proceed. The Secretariat cannot find out so much information from just a simple inquiry, and it would be risky for the Secretariat to say yes or no. Such information has to come from the service recipient, the donor, the conditions, physical conditions of both, and all the things before decision can be made. Now, we'll talk about sex selection. If someone writes to the Secretariat, putting such a case to it, there is a service recipient who would like to bear a son because his or her son has passed away because of certain disease. So we can only tell the inquirer that under some basically sex selection is not allowed, but if there some sex-linked hereditary disease, then it is possible. So we will have to ask whether either of the parents have any sex-linked hereditary diseases. And for such details, it cannot be known to the secretary. Now, for instance, if the purpose is to replace the deceased son, we don't know whether the son has any sex-linked disease, so on and so forth. So for details, we can only have them after in-depth contact with the service recipient. Well, if the council cannot answer these inquiries, what other assistance can you give? The council will provide all the details and will say that if they have any doubts, they can consult their own legal advisor. Because if the council has its own queries, we consult our own legal advisor. The legal advice from us and from their own lawyer, they're the same weight. Mr. Chong, well, what if his legal advisor is not in this profession? He can only read the provisions and explain to the subject, and so it's not really useful. The Deputy Secretary that there is room for the ordinance to be reviewed and amended, but there is no time frame for that exercise. Recently, guidelines can be done internally. I don't believe HRT can be more complicated than issues related to competition. So, pending amendment to the HRT ordinance, can guidelines be made by the council for the profession to follow? Mr. Leung said that all these guidelines should be given to the relevant doctor or persons concerned for consideration. Now, if all such information is passed on to the council and the council sets up a committee to vet such information, is it feasible? Mr. Leung, we do have a code of practice. We've done our very best to set out things as we understand it in a code of practice. The code of practice was recently revamped, and it was only introduced in the past year or so. So, to borrow the practice of compact or the competition commission, as Mr. Zhong said, if you can have guidelines to include cases with detailed analysis, it may be useful to the council as well as licensees. In fact, we're already doing this. From time to time, the council has received complaints or inquiries. Under some circumstances, the council as well as the doctors concerned or licensees concerned have their own legal advisors, and we will just note the different views, and we have got a thick code of practice, and there it contains some specific advice for licensees or service providers. For instance, an example involving two Muslim couple was mentioned. We know that there were such cases, and the administration would really seek our own legal advice to see how the provision parties to a marriage should be interpreted, because there is such a term in the bill, in the ordinance, with no interpretation or definition. We will ask other government departments to see what are the arrangements, and if review has to be done, then this will be included. But if there are issues not related to our policy, and if we get the green light from the DFJ, then we can add some provisions in the code of practice to let the industry understand better. So we will do two things in parallel to help couples seeking help. We will do what we can by amending the code of practice as soon as possible. Mr. Zhou, according to the administration, some cases can be included in your code of practice. So what would be the procedures? Will the industry have to give you these cases first? We have a working group to work on the code of practice and to see how the code has to be changed. And the procedures for changing it is rather lengthy, but we've promised to consult the industry before amending the code. But about a year or so ago, when we consider cases together with treatment centers, and if all other treatment centers should be informed, we will send letters to them. For instance, if we come to a decision after discussion with a treatment center, our secretariat will write to all other treatment centers to alert them of the latest situation. So before the code is amended, we will write letters to treatment centers to notify them how many letters have been sent in the last year. That depends on the number of cases, Dr. So. Chairman, I don't have the actual numbers with me, but in a recent incident, we allow a treatment center to use a certain type of donated gametes for treatment. And as found that cases approved a few years ago had not proceeded. And because the gametes have been held for a while, and we're of the view that the situation is not very satisfactory. So we've decided that a treatment must proceed within half a year as far as possible after approval has been given by the Council to use certain donated gametes. And this letter was sent to all licensed centers asking them to comply with this. Mr. Zhong asked about the question of legal advisors. We believe we do not have many lawyers that are familiar with the implementation or operation of the ordinance in Hong Kong. So where can they find the right legal advisors to help them? And how will the Council address this issue? If a treatment center comes forward to ask for assistance, how will you deal with it? Of course, a legal advisor can only provide advice on the basis of the law. The Council has got its own legal advisor. When the Council has any query, we will consult our own legal advisor. But usually, the legal advisor will only comment on issues instead of individual cases. If there is a suspected case of contravention, the legal advisor, of course, will consider that case. And therefore, if a treatment center has doubts, it should also approach its own legal advisor, and all the exchanges between the center and the client should be passed on to the legal advisor. And it is for the legal advisor to come to a decision based on that. That's the current situation. Mr. Chung? Mr. Leung said that the legal advice obtained by the council may be different from that of the center. So what happens then?
Is that our legal advisor in the same center, if you go into the same center, of course the legal advice would be the same. But if you already have a precedent case in court, of course that would be much easier. Otherwise, the weight for the advice would be the same, and the center would have to make a judgment. You have to understand that if he believes that only one legal advice, then there's not much help to the center, because if there is any liability, that would be upon the center. If the law is not clear, then there will need to be amendments made to the law to make sure that it won't happen. All right. There are two questions I would like to ask on behalf of the deputations. I would like to ask Dr. Leung if the constitution of the council is believed not to have enough expert representation. You gave an example saying that there would be a more comprehensive review in the future, which means you would need expertise of HRT on the council. Last time one deputation said that you need to read the medical journals every 2 weeks to update yourself on the latest technology. Dr. Tang is already retired. Do you believe that this would affect the council on keeping up to par with the latest technology? If this is not an ideal situation, would you suggest consider appointing experts on reproductive medicine into the council? Second question, legal consultation takes a lot of time and is costly. Not every complainant is well off. You should help those seeking help to address their concerns. How are you going to help those in need? Through the licensees to seek faster services, because those affected are not the centers. It's those who are seeking assistance. Because if they're not able to seek help in one place, then we'll just go to another. It's just going to build up the pressure on them. Regarding experts, our council welcomes new technology. In our working group, of course, we welcome experts to join in our discussion. Experience shows that persons engaged in the practice of obstetrics and gynecology are quite experts in this area. Remember using genes of 3 people to create a fetus. I remember we discussed how 3 people's genes can be taken out to make an embryo. Well, I think if there are experts on board, of course, that will help us answer questions. But overall speaking, I welcome experts to participate in our discussion because it would be very conducive to our discussions on the Council. Very often, in our consultation, after consultation, we would find that we are unable to do anything. Because if it's possible, they wouldn't come approach the Council. So these are the current provisions in the law. Because we're limited to the current provisions, many cases cannot be dealt with in Hong Kong because of these limitations. Well, I hope the government has heard Dr. Leung that the Council welcomes experts on reproductive medicine. We look forward to the government coming up with a timeline to review the HRT bill because it has already been effective for over 10 years. And secondly, in the appointment of council members, we as legislators also have expectations. There must be someone who's an expert in this area so that you will be able to deal with these issues. Well, if there are no other questions on the Council, well, let us move on to paper 2 on the definition of advertisement. So you can see that in Annex A. The term advertisement is defined in the ordinance to include any form of advertisement, whether to the public generally or to any section of the public or individually to selected persons. Thank you, Chair. Well, there's a question that in the government's response, I see that Clause 16 and 17 has similar clauses. I also see from the Hong Kong Bar Association submission that the Clause 16 and 17 are very different from Clause 15, especially in Clause 15 it talks about prohibition of sex selection services, which means that it does not contravene Clause 15 if it is done outside of Hong Kong. The Hong Kong Bar Association does not have a very strong basis to curb these advertisements. But if you want to narrow this down, would it contravene freedom of speech in Hong Kong? Because the rights law in Hong Kong also define that there should be freedom of speech in Hong Kong. So can you also tell us what you think? Well, yes, we have received the submission given by the Hong Kong Bar Association in 2014. And we have seek the advice of the judiciary. Perhaps we could ask Mr. Look to address your concern. Yes, we have received the comments of the Hong Kong Bar Association on Clause 15 not comprehensively contravening law in Hong Kong because it said that sex selection services could be done outside of Hong Kong, and that if we narrow it down, it might affect freedom of speech. But if you could refer to our overall response in paragraph 2, if there are medical issues that would need persons to receive the necessary information, then we will not restrict that. So in paragraph 2, we said that having regard to the clinical and ethical practices of the local medical profession, we consider that banning all advertisements on sex selection services using RT procedures would not restrict the right of persons with genuine medical reasons to receive the necessary information, because these people already have local doctors following their cases. Thank you, Chairman. Mr. Lok, I'm still very unclear because the comment of the Hong Kong Bar Association is very clear. We are not prohibiting all sex selection services advertisements. We just want to prohibit those outside of medical reasons. So, should you prohibit advertisements outside of medical reasons? Well, and secondly, you said, that, those patients already know or understand the situation because they would have doctors following their cases. Well, we can't assume that everyone has already sought medical assistance before reading the advertisements, and we cannot assume that all doctors are clear about the HRT bill. I'm sure if you go ask a family doctor about the HRT bill, they wouldn't be able to answer you anything. So the government's response right now is that, oh, you've already assumed that they have seen a doctor, and you already assume that the doctor has already given a reasonable medical advice. And if you restrict all advertisements, that actually poses a problem. Have you thought about that? Well, let me try to follow up. First of all, we need to read the provisions. The government's suggestion on prohibition is not what I said. We've already responded in our response. Well, you should look at the provisions very clearly. Right now, we are just prohibiting the advertisements, and the advertisement as defined in an ordinance is a form of advertising, a kind of promotion. We prohibit the promotion of sex selection services. That area is not part of medical discussion or providing medical advice to patients. Secondly, when we look at the provisions, we see that there are these kind of advertisements in Hong Kong right now. The format of the existing advertisements do not specify whether the technology is used on people with medical needs or without medical needs. So when we are drafting the provisions, we need to make clear whether we could effectively prohibit the current advertisements. Or some of the advertisements right now do not specify whether the sex selection services are used with or without medical reasons. So after considering all factors, we cannot prohibit all advertisements, because if we prohibit all, then those persons who really need such information would not be able to receive such information. So doctors who are referring them to seek such services should not be under these provisions. And we believe that the current provision would not affect those in need to seek such information.
I'd like to consult our own legal advisor. The submission from the Bar Association is very clear, and that is the bill restricts sex selection services on non-medical grounds. So I'd like to ask the administration Dr. Choi from the Department of Health said that it would be impossible to specify in the provision of whether the sex selection service is on medical grounds or not, and therefore they've decided to ban all advertisements on sex selection services. So I'd like to know whether there have been any precedent in the past. I think we understand that the Bar Association is not against the administration's proposal to ban such advertisements, but their concern is the consistency. The ordinance bans sex selection services on non-medical grounds. However, the current bill is such that even advertisements for the purpose of sex selection on medical grounds will be banned. So, will this be a precedent in the future? Will everything be cut, no matter whether it is on medical or non-medical grounds? And Dr. Choi said that there's some difficulties in enforcement. So I'd like to know, what are the difficulties in enforcement? What are the operational difficulties? Now, if there is a commercial organization that advertises sex selection on non-medical grounds, then it will be caught. So why don't you go for the Bar Association's proposal? And that is, you will only control advertisements to promote sex selection on non-medical grounds. If you specify in the bill that only advertisements purporting to promote sex selection services on non-medical grounds, then you are creating a loophole. Because if there is a business that wants to advertise on such services, and if it knows full well that sex selection on non-medical grounds would be against the law, it would just drop that part, so as to circumvent the law. then it would be difficult to enforce the law, because they will first attract clients into their center before they sell sex selection services on non-medical grounds. Or the advertisement can be entirely silent on whether it is for a medical or non-medical purpose. Then it is hard for us to gather evidence or to prove the offense. Mr. Look, what about other controls on advertisements? Will the same principle be used? Say if it is difficult for the enforcement agencies to make a distinction, then all such advertisements should be banned. In Annex B, we have got some provisions related to advertisements. Of course, the policy intent and the legislative background may not be entirely the same as this one. But I think usually the provisions were drafted in a rather general, in a more macro perspective. We know that the Bar Association may query whether there is any inappropriate restriction on receipt of information. But, as said, for needy couples to receive legal sex selection services in Hong Kong, it must be on medical grounds. And the reasonable presumption is they are already receiving medical services. They have their own doctors to follow up. So we fail to understand how such control on advertisements can restrict their freedom to receipt of information or access to information. Dr. Choi, the chairman asked whether there were precedents where the scope of restriction on advertisement was wider than the restriction on the Act. It depends on whether it is morally or culturally or socially unacceptable to the public. So, after so many meetings, I have the impression that people do support, our members do support sex selection. And Section 17 of the HRT Ordinance has an example. It is a ban. There is a ban on surrogacy arrangement on commercial basis. Now, we do not ban surrogacy arrangement. What we ban is surrogacy arrangement with a commercial nature. And Section 17(2) mentions advertisements. It says that no one can cause to be published or distributed or knowingly publish or distribute an advertisement on surrogacy arrangement, regardless of whether the advertisement invites people to do something against 17(1). That means all advertisement is banned. So even though it is not of a commercial nature, yes, it's banned. So I think it's a similar case for members' information. If there is an advertisement inviting someone to act as a surrogate, we cannot tell from the advertisement whether it is a commercial nature. We don't know whether the surrogacy arrangement is a commercial one or not. So, surrogacy of a commercial nature is banned, and advertisements or on surrogacy are all banned. We believe that provision has served us well, and members may want to consider it. I think there is a similar reason or rationale behind the two, and this example may assist your understanding. Okay, Mr. Chen Chi-chun. If I may respond, I think with the exception of myself, there's no one in this Bills Committee who would like to loosen your moral threshold or to lower your moral threshold. But I think the administration wants to cast the net as wide as possible so that there won't be any loopholes. We say if you only bet advertisement on sex selection on non-medical grounds, you said there would be loopholes. We asked for defenses. You said that again it will create loopholes. We talked about seminars and workshops. You said that they won't be caught. You talked about menstruation and this and that. In para 3, you said that we're also aware of the possibility of individual persons or organizations using educational talks or workshops as a cover. So if a doctor's name and a clinic address is provided, then it may already be an offense. And you talked about implicit or a display of information. And you also assume that these people can have access to information from their own doctors, and therefore there is no restriction on access of information at all. But what if people would want to know more about sex selection services? A patient may not just accept the suggestions of his or her doctor. The doctor may tell him that you can go to this or that clinic in the US and Thailand, and he wants more information. Does he have the right to more information? You only say here that no needy couple must be able to receive the relevant information. If it is really on medical grounds, surely the doctors would give them such information. Agree. But I think the person's right or opportunity to more information will be restricted. Yes, I don't think I can change the administration's view. If we don't like it, we can only move our own amendments. But I just want to let the administration know my view. Yes, we have been thinking about this. If we want to ban advertisements, we don't want to provide too many loopholes. We want the bill to be effective, while we know that there cannot be any 100% control. For instance, information through overseas websites and the internet is something we cannot control. Indeed, we have considered that people who have genuine need of such information will not be affected. While I'm a layman, I think Dr. Choi can supplement. Dealing with sex-linked disease is something not very common. Now, for healthy diets, healthy living, this is information we can have access to easily. But when it comes to sex-linked diseases, we are talking about specialists. If a couple is diagnosed to carry sex-linked diseases, we believe these needy couples should really have to rely on advice of specialists. And if they've decided to raise a child, regardless of the situation, they have to make a choice as to whether sex selection should be done. The whole process relies heavily on the handling of a specialist. I believe needy couples and their specialists would not be inadvertently or easily caught. We have a definition in the bill, and while advertisements can have very wide scope when it comes to HRT and sex selection of embryos, given that we have added these definitions. Well, if it is not really a genuine advertisement but educational talk by a scholar, we believe with all the basic principles there won't be people inadvertently caught.
We don't want to make it very lax. This is not our purpose or our desire. Well, I'm just afraid that it's too broad and that nothing would be done, because because if the provisions are not clear, it doesn't really safeguard ourselves, and we would choose not to do it. Well, I think in Annex A, last time we requested the judiciary to list out the examples of provisions that contains purporting to, and in Annex A we have used Companies Ordinance Cap 622, Money Lenders Ordinance Cap 163, Places of Public Entertainment Ordinance Cap 172. These three are all examples of provisions that contains purporting to. I'd like to ask Mr. Look. These are not exhaustive, right? These are only a few examples, is that right? Or Mr. Look, can you tell us whether there are more provisions that contains the term purporting to? I think there are over 700 provisions that contains purporting to, but as to the exact way of how you use this term, it's different. Purporting to be, there are over 500 provisions. Because in our last discussion, we were concerned about the term purporting to, because people might be victims when you use such a term. Mr. Chen Chi-Chen just now mentioned whether related advertisements, would be assumed as contravening the law, because I'm sure if you use the term purporting to, then many of the advertisements would be very broad, and they would not put any wordings in it. Would it make those patients who really need such sex selection services to receive the information they need? Has the government done any sort of assessment? No? All right. If you do not have further questions pertaining to purporting to, then we will move to the definition of sex selection services. So there have been responses given by the government. Any questions? No questions? Legal advisor? Thank you, Chair. On the term purporting to, I see that there are many provisions that also use such a term, but I see that in many provisions, it would say that if the court, if there is evidence submitted to the court that is purporting to a signature of a certain secretary, then you wouldn't need the secretary to attend in person, but there's not many definition that use the provision purporting to in advertisements. Would you consider changing the Chinese to 容易試 because 看來試 the term in Chinese is quite controversial, or because how would you define it better to make sure that it is clear to the public? The Chinese, we still use 看來試. You can use on page 13, number 3 in Annex A. This is the places of public entertainment ordinance. Under section 6, no person shall sell or offer or exhibit or have in his possession for sale or solicit the purchase of any ticket or voucher authorizing or purporting to authorize admission to any place of public entertainment license under this ordinance. Well, there are too many. Well, I'm not going to continue reading. Well, basically, we use the term purporting to here. Let's put it back into our own background. Well, it can be used as reference. Well, let's say someone is selling tickets outside of the real box office. The tickets sold might be real tickets or might be fake. The advertisement on sex selection services may be able to provide such services or maybe not. So this is just the context. So your view is that purporting to is to deliberately to draw a fine line so that if it's so whenever you talk about sex selection services, then we first assume that you are providing such a service. Well, I don't mind if you think that we would need to make this definition. That's all right with me. But would this be appropriate? I also want to know the background. Mr. Look, you gave the 3 examples, especially the 3 examples listed in Annex 2. Was Cap 622 passed recently? Because this is not a very clear legal term. When were these ordinances amended or drafted? The first one is new. So this one is new, right? The company's ordinance should be 2010. Well, this is not an old term. This term has been used quite frequently in legal papers. Any questions then? No? All right. Let us move on to definition of sex selection service. It seems that there are not any questions, so let us move on to page 4. Legal advisor, do you have anything to say regarding the mens rea or the actus reus? Well, my own concern is that if I look at para 13, C and D, mens rea, if a person who causes the advertisement to be published or distributed, the word causes implies the intention to get the advertisement published or distributed. Well, so many people would fall into this category. because those who are in publishing and printing and distributing would fall under this category. So would you consider amending it so that this is not the person who causes to be published or distributed? No, thank you. I also have my views, because the defense only talks about internet. I talk about hyperlinks, etc. For those who are in printing or publishing, then all these people would fall under 15C. Would this be too broad? Because, well, if you are suing anybody, you are suing the person who made the advertisement. If you also sue those people who participate in the publishing or printing, that would be too broad. Well, so can you tell us, so which parties would be sued? Well, if you just read this, then it means that everyone who falls under the category would be sued. Well, don't believe them if they say they're not going to sue. I'm sure they would. If you fall under 15C, then everyone involved would be arrested. Well, I'm not afraid of people being accused, but they might choose who to arrest, because this is too broad a definition. Ms. Au, I'd like to address Mr. Chen Chi-chun's concern. Well, this is a very simple hypothetical question, so I'd like to try to address it. Well, okay, so if there's an advertisement that shows up on the newspaper, let's say that this is an advertisement, so we would see which company paid for the advertisement, who's the intermediary in charge of the advertisement, or which publication it is. Well, let's say there's no intermediary. Then we would go after the person who made the advertisement and the publication. For those colleagues who work in publishing, printing, or how about advertisement sales? We've already asked our legal advisors. So when they are going to prosecute, then we would first look at the behavior to see whether this advertisement is reasonable. Is reasonable, whether it is really promoting the services of sex selection services. We would also consider whether there is an intermediary in charge of distributing the advertisement, and we would also consider the publisher. Is this perpetrator someone who knows that this is contravening the law? So the prosecution must prove not only the actus reus but also the mens rea, and that they both coincide. So when they are prosecuting, is it really in the public interest to arrest everybody involved? Of course, it will also depend on the individual case. Ms. Au, so where you say the person responsible, would that be the publisher, or would that be the who would be the person responsible? I think if we just look at the service, this would be the person or the company who's paying for the advertisement who decided to make this advertisement. I can't really tell you exactly who we are going to prosecute, but the prosecution would not be made against those who are in trivial roles. Okay, so the person who made the advertisement, the intermediary, and the publisher, or whether it be a magazine or a newspaper, these three, if I understand correctly, are not trivial people. So these three would be the would be prosecuted, right? All right. Yes, those who fall under these three categories would be prosecuted in future.
So we're worried that in the process of people who have assisted in this matter is not very likely to be prosecuted. Now, you have to understand the role of a lawyer. Now, we will mainly focus at the person in charge of these organizations, not the employees. Usually, it is a treatment center that takes on advertisement, and so we usually prosecute the in charge of the treatment center. And as for the media, you may be worried that the intermediary may be a person, and if he claims to be an employee, we are worried that it is an loophole for the treatment center to abuse. So we just want the provision to be really effective. And it is for these reasons that we do not want to add any defense. There may be employees who are not really entirely reluctant to take out such advertisements. Can you please give us case examples of restrictions on advertisements? Please give Mr. Zhong and the DOJ some time. Maybe your bureau or the Department of Health are familiar with the Undesirable Medical Advertisements Ordinance. And I'm sure the one who takes out the advertisement and the intermediary and also the person in charge of that media will be involved. If you have such information sought by Mr. Chen Chi-chun, please let us have it after the meeting. These three categories of people that have been prosecuted in the past, if you have information or if you have similar cases, do let us have them. And you said that people who have a too frivolous a role to play in the case will not be prosecuted. Ms. Ho, I apologize because I was at another meeting. Understood. There are 6 meetings going on. Mr. Leung? I think he is the officer responsible when the ordinance was enacted, so he knows very well the inadequacies and loopholes in the ordinance. However, a decade or so ago, the internet was not so popular, and back then people mainly have access to such information from the printed media. But nowadays, there may be procedures done overseas with advertisements done in Hong Kong. Indeed, it is very difficult to control such situations. Recently, we are now studying the Copyright Amendment Bill, and we have a safeguard or safe harbor for Internet service providers. Even though infringing copies may be found in a particular website, the service provider is exempted. So when it comes to sex selection services, who should be held liable? We really have to use the same logic. Because as I heard from the official that the government would not really prosecute trivial cases. Unfortunately, this is not the case recently for public places of public entertainment. Mr. Leung was responsible in the past. The administration or the DFJ used that ordinance to prosecute the Hong Kong Alliance in support of the patriotic movement in China for placing the statue of goddess of freedom, of liberty, and the case is pending a hearing. So even if out of goodwill, I trust that the administration will not prosecute really trivial cases. But unfortunately, the government has people who are evil enough to abuse the law to prosecute people. Even legislators blame the court for releasing people prosecuted by the DFJ and arrested by the police. This is how the administration or the government operates now. I don't know who will make the decision to prosecute people using this ordinance. Our good will or good intention cannot be above the law. If it is even more horrifying. Here it says a person must not cause to be published or distributed or knowingly publish or distribute on an advertisement purporting to promote sex selection services a person. So everyone will be caught, no matter whether you are the publisher, the in charge of the treatment center or what. So when we examine bills nowadays, we must clearly allocate liability and responsibilities. We must not allow a draconian law to be passed, or we must not pass a law that will allow evil people to abuse. I was new to the council when the HRT bill was examined. Nobody was willing to be chairman, and I was elected chairman. So I still have a vivid memory of the bill. Nowadays, people can use the internet, and for the printed media, they have in-house lawyers to ensure the legal liability. But for internet service providers, there are people who like to place things in other people's websites, and if you ask the service provider to be liable, it is unfair. So we must view this matter from a new perspective. Chairman, that's what I want to say on the bill. I agree that we should legislate to restrict sex selection services to for medical grounds only. So, but I have a really reservation about this provision on advertisement. May I supplement? Before you came in, Mr. Leung and Mr. Chung said that although there's no time frame, the HRO has been in place for a long time, and some of the details have to be reviewed, but no timetable was given. I hope they will honor that promise. It's impossible for me to press Mr. Leung or Mr. Chung to conduct a review soon because it is outside the scope of the bill. So the provision here is very broad, and there is no specification as to who will be prosecuted. Yes, I don't trust the administration because the responsible officers in the future will be different from those sitting here. To be fair, I don't believe in the judgment of the officials sitting here of this government because we have too many real examples to tell us not to trust this government. I share your view, Mr. Ho. Mr. Zhong. Well, Mr. Look has talked about the makeup of the provision, and now I think to establish the offense, it is a very stringent procedure because there are a few elements in the provision, and the DOJ has to consider the evidence. Although the provision is not very long, with not too many elements, but I think the gathering of evidence and prosecution is a very serious matter. Can you say amend it to any person who provides HRT? I'm referring to 3A, Section 3A. So according to the visual, they want to control people who provide such services. So you don't use the term a person. Is that possible, Mr. Look? If we just cover any person who provides HRT, then there is an obvious problem. They can easily contract out or outsource. Yes. There are pros and cons for both approaches, and we are considering this from two different positions. I welcome the administration to reconsider its position, having heard our concerns. Now, we know that you just want to regulate HRT licensees, or you just want to prevent any outsourcing, then please consider narrowing down our differences. Now, you asked me to take the provision as it is. I won't do it, but I am willing to negotiate with you. So you know Mr. To's view. Mr. Look, no, Mr. Zhong, please consider. And our legal advisor may also assist in this regard. Can we confine the scope to people who have the mens rea and with obvious interests involved? So there must be the mens rea, the motive, and the interest. Because the provision is drafted in a very broad way. While you say that you're not going to prosecute trivial people involved, we are worried because the law, once it is passed, unless luckily Mr. Ho is still here, otherwise you may say that you have never promised to adopt such a narrow scope in prosecution. My view of the future prosecution standard is to prosecute any person. Do you understand that, Mr. Look, that the public prosecution policy may change tomorrow? Even the one who types the advertisement, or who make the publishing and setting will be prosecuted. Chairman, that provision is very selective because the places of public entertainment ordinance is such that so long as you give a talk or tell a story in a public place, the place will become a place of public entertainment. You look at our officials, they are cheating kids, telling stories in public places, but they have never been prosecuted. Mr. Look, how come you've never prosecuted public officers? Chairman, if I may refer you to para 13. Now, if you have concern about the provision, yes, I do understand it. The provision may be long, but may not be long, but you can see that the standards are tight.
First of all, as long as there is such a behavior, then you would be prosecuted. Distribute or publish advertisement purpose. And paragraph 13 also said that the actus reus and the mens rea must occur at the same time. It's not that easy to fall into this category. First of all, there must first be an advertisement, and then the advertisement has to promote certain services, and that must be sex selection services according to para 3B. Well, if you want to fall into this category, that's not easy, and there must also be a mens rea. So I can say that it's not that easy to really fall into this category. Well, you can see that, the government would very often choose whom to prosecute. And so when we are reviewing the provisions, of course, we must ensure that whoever is prosecuting or whoever is enforcing would not abuse the provision. This is the responsibility of the Legislative Council, so we must be very cautious. What kind of advertisement is not a kind of promotion? All advertisements promote something. So you have to understand this. I think we've already requested Mr. Look that in 3A we have asked Mr. Look whether there you could narrow down the people or persons involved, and to try to look for other examples similar. And regarding the internet, in para 15, a case is shown. MIS, which is Metropolitan International Schools Limited versus Design Technical Corporation. We don't have local precedents, so only this English case was shown. Has this case been referred to in the local courts, Mr. Look? Oh, I don't have this information as of now. So when you're collecting information, this case may not have been used in Hong Kong, right? Well, Mr. Look, you referred to this case in para 15. Does it mean that in future, when we are discussing discussing this in court. The case listed in paragraph 15 now, you could refer back to this case in future prosecution. Is that right? So when what is done in the future has deviated from your draft objective, then you would refer back to paragraph 15. Well, I can say that the cases in the UK are not legally binding in Hong Kong. The discussion here is an internet search engine operator. And the information generated automatically in response to search terms. And this was only a discussion on whether this search engine played a role in facilitating the appearance of these snippets of information on the user screens. Okay, so this is only for reference. It's not legally binding. Or if we pass this bill today, then this case is only for reference. Let us move on to paragraph 16, 17. Mr. Chen Chi-chun. Paragraph 16 regarding editorial or maybe feature articles. Well, in the past, when we are advertising or writing about a restaurant or promoting a restaurant, then we wouldn't give the name and address. But today, we would put down the restaurant name, the opening hours. We don't know whether any money has been charged. Is it a paid feature article or not? Or did the reporter really think that this restaurant was so good? Let's say I want to introduce or share a Thai case. Of course, there won't be any problems if I just talk about it. But if I give the address and publish the services it provides, then, would it be contravening or violating the law? Of course, I think ultimately it depends on the person to make a judgment. I could also ask for foreign doctors' advice on these services. If that person talks about the services it provides in Thailand and gives the price, would it be considered not a scientific forum or a feature article? Thank you, Mr. Chen, for your question, and thank you for mentioning about feature article. There are many feature articles. Some are real features, real reports, and usually no names would be shown, because for those that show the price list and the services, then it would be more inclined to be seen as advertisements. But if no names are shown, then it's not really seen as an advertisement. Or let's say for academic purposes, and we discuss the latest technology. Of course, that would not be seen as advertisement, but in the small working groups underneath the forum, and you really talk about the names, then it might be inclined to be seen as advertisement. So if the name and the price list is put forward, then it would be seen as an advertisement. Well, of course, we need to look at the totality. But this might affect how you see advertisements. Well, of course, I know you can draw a line anywhere. But recently, feature articles and editorials really would give more detailed information. For example, a website or a contact number. Well, I can't really tell, whether they have been paid money. Of course, there in the past, there are no free lunches. But we don't know today. Well, I'm just talking about restaurant. Well, some restaurants want to do a promotion, so they would give more detailed information on the feature articles. This is the gray area I'm talking about. Well, yes. When you look at the articles on the internet nowadays, most of them are, as Mr. Chen Chi-chun said, there is a website listed. The internet advertisements operate in a different way. Maybe that article is not being paid for, and there is no obvious benefit. Would monetary payment be considered as a kind of advertisement? Well, we are just worried about whether this definition is too broad, that for those who are really not trying to advertise could also fall into the category you mentioned. Mr. Lok, it's very difficult for me to try to put this in different context. It really depends on the ultimate evidence. Mr. Chong, the examples given by Mr. Chen, we would enforce the law on those two examples. Many advertisements would refer to the service provider, and as Mr. Chen said, there is a price list or the name of the service provider and even the number. Of course, I cannot represent the judiciary, but I think under these circumstances, this would be something we would investigate further. For local media, once the bill is passed, we would allow a grace period for the media. We would disseminate information so that they would have a better understanding before the law comes into effect. Well, when we are on working on the radio station and we keep on referring to one restaurant, then of course people would think that you have taken money. But if you're talking about restaurants from Taiwan, from Thailand, and talk about 3 places, it will be seen as giving information to the public. But on the internet, you would show maybe 3 restaurants with prices listed and contact information. I mean, from the reader's view or from a consumer's view, to get more information on the internet, I mean, this might not be a paid advertisement. Well, I understand your concern. It's actually very difficult to make a judgment on the internet. Those who write on the internet most likely do not know of this ordinance. I'm sure those who operate websites or those who write feature articles would not read all the relating bills before writing their articles. So, they would very easily be prosecuted. Because if you put down the name of the restaurant, you put down the price, then you think that it's already violating the law. This is very worrisome, because in future many people would unknowingly violate the law.
Mr. Chong. A few conditions have to be satisfied. First, the mens rea. And as for the search engine, it may not satisfy the mens rea condition. So, indeed, the decision to prosecute has to go through a very stringent process, and for local media, local newspaper will certainly do it. Local website, yes, not because it is easier to enforce the provisions, but rather for local newspapers and magazines and web pages. Obviously, the target audience are local people. All right, thank you. Mr. Chong. It's about time we end. We asked for supplementary information from Mr. Zhong, and he talked about prosecution of internet advertisements. So perhaps the Department of Health has more information when enforcing the undesirable medical advertisements ordinance. So please give information on who have been prosecuted, and let us have information on such prosecutions. Chairman, I have a question, but the administration need not necessarily answer today because it's about time we end. This is about enforcing the law overseas. A few years ago, there was a case which very high-profilely told us that 3 babies were born of a surrogate mother overseas, and the grandfather was very, very happy. Of course, it is something to be happy about, but we have a law saying that it is against the law even though the surrogacy took place overseas. However, the government turned a blind eye to the situation. It was not until LegCo asked for follow-up action that Professor Yorkchild said that yes, he would follow up, but we were not told of the outcome. So please tell us what was the follow-up action to the very happy event that took place many years ago. Surrogacy is legal overseas. And as you said in the paper, it is very difficult for you to get the evidence in places where such a thing is not an offense. So we are talk about regulating advertisements on the internet. So please tell us whether it is practicable. At least please tell us what's the progress of the last case. I don't think they will tell you anything about individual cases. Why don't you ask the administration, has there been any prosecution on surrogacy? If yes, the number. If they tell you the number is 0, that means they've never prosecuted, or perhaps they have not concluded investigation. Any immediate response from the administration, Dr. Choi, or please give us a reply in writing. I want a written reply. Yes, that's what I'm asking for. Suspected cases of surrogacy and advertisement on surrogacy, please. According to information I have, we have never prosecuted. Have you ever done any investigation and follow up? Yes. How come you haven't been successful even after 2 years? As the chairman said, it's hard for me to respond at this moment. Yes, please give us a paper in reply. We know that it is difficult for you to come on individual cases, but please give us information on past investigations, the reasons for starting the investigations, and the reasons for not prosecuting. We don't have too much time left. Our schedule is very tight. All right, our secretary has checked the availability of rooms, and we also like to give the administration enough time to respond. So please give us the papers we asked for before the next meeting. Thank you.